Hi, everybody. This is Nancy Warner. I'm General Counsel at eNATOA, and I am moderating today's eNATOA session on recent cable franchising issues. So welcome to everybody, and thank you for participating today. We have three great panelists and a lot to talk about, so I'm going to do just a brief introduction of all three of them, and then we'll get started. Our first presenter will be Jerry Lederer, who is a partner at Best & Krieger in the municipal law practice in the firm's Washington, D.C. office. Tim Lay is a partner in the Washington, D.C. office of Spiegel and McDermott. He also represents local government on telecommunications, cable, television, franchising, right-of-way issues. And finally, we have Garth Ashbaugh, who is a CPA with Ashbaugh & Skolko, which provides consulting services to local government on franchise fee reviews, right-of-way cost studies, among other things. I think most of you are familiar with these three gentlemen, so I don't think I need to go into more detail, although I will mention that Jerry was the 2011 NATOA Member of the Year, Tim was the 2006 NATOA Member of the Year, and Garth is a life member of NATOA, as well as the Secretary and Treasurer of the Board. So we've got a lot of dedicated years to NATOA on our panel today. So we're going to start with Jerry and Tim, who are going to talk about some recent FCC filings by the cable industry, asking for FCC rulings that would impact cable franchise fees, but which also might well extend beyond cable franchising because, as many of you know, there are ongoing FCC proceedings related to broadband deployment, and these cable filings are somewhat intertwined with those ongoing proceedings. So there is a larger threat to local authority over the rights of way and local fees beyond what the cable filings are. And then after Tim and Jerry present, Garth will be discussing what is at stake in terms of your fees and issues with some of the proposed changes to local fee structures that the FCC is contemplating. And after that, we will have hopefully some time for some question and answer. And please don't wait till the end. You can submit at any time your questions through the question function that should be on the right-hand side of your screen. And with that, I will turn it over to Jerry.
Hi, good afternoon, everyone. Thank you very much, Nancy. So Nancy says that we're going to talk about threats that are facing us right now at the FCC, and you're looking at my screen and you're saying, wait a second, Jerry, the 621 orders happened back in the early 2000s, the 2004 to 2007 time period. What's going on here? And I don't know if local government cable practice before the FCC is like a soap opera that you can keep coming in and out and the issues pretty much stay the same, or if it's just the more things change, the more they stay the same. We're going to walk through the issues that were faced in the 621 order and that the court overturned, the court being the Sixth Circuit last year, because those are the exact same issues that we see that are now being in play. So what were they? These are the biggies. The FCC, through a series of orders issued over a decade, decided a couple of things. One, it says that localities could only regulate cable operators in the provision of cable services, and we could not enforce customer service requirements in connection with the provision of non-cable, non-common carrier, i.e. internet services. That's called the mixed use rule, so keep that one in mind. The Commission also said that the value of any in-kind benefit provided to a locality could be deducted from the 5% cable franchise fees. So things like PEG channels and services to schools and government buildings. Now, most of the cable operators didn't try to enforce that rule, thank goodness, before the Sixth Circuit overturned it, but that's what the Commission said. And then what they said was that localities could no longer require that operators provide an institutional network as a portion or a part of a cable franchise that's negotiated. So these were three very, very ugly rulings that the Commission had that were before the Sixth Circuit. Now, how did we get to the Sixth Circuit? Well, what happened was that the order first came out in 2007, and it was appealed up, and it was upheld by the Sixth Circuit. But at the same time that it was appealed, there was a motion for reconsideration that was filed on the second video franchise order. The second video franchise order was the FCC's attempt to try to say, when does this apply to a new franchise? That was the first order. The second franchise, how do these new rules apply to incumbents? We petitioned on behalf of Montgomery County and a group called Tech Philly, which is the Texas Coalition of Cities for Utility Purposes. We filed a reconsideration petition in 2007. The commission finally got around to answering that recon petition in 2015. They reaffirmed everything that they had done in 2007, and we immediately went up to the Sixth Circuit on behalf of Montgomery County and Tech Philly. All right, come on, machine work. There it is. And then it goes too fast. So before the commission, before the court, there were these three issues then, right? There was the mixed use, the non-cable authority, and the eNATOA issues, and then in kind. So what did the court find? Well, the court found with respect to non-cable authority, this is the mixed use rule. The court found that the commission's the FCC orders offered no valid basis, either statutory or otherwise, for its application of the mixed use rule to bar local franchising authorities from regulating the provision of non-telecom services by incumbent cable providers. Thus, on the record now before us, the FCC's extension of the mixed rule use to incumbent cable operators that are not common carriers is arbitrary and capricious. So what did that mean? What does it mean today? It means that states and localities have a clearer path to protecting consumers, even with the FCC's reclassification of broadband services from being a Title II or a common carrier service to an information service. It also means the privacy issues surrounding the provision of non-cable services can be addressed. So that's today's law on mixed use. On in kind, the commission, the court said that the commission's second order and recon order did not reflect any consideration of the concern, which leads to our second contention that those orders contain scarcely any explanation at all for the FCC's decision to expand its interpretation of franchise fees to include these so-called in-kind cable benefits, these cable-related exactions. And apart from a fleeting reference in the recon order, the FCC has not even defined what in-kind means. So what did this part mean to us? What is the current law? What restores the long-standing status quo under which localities, as part of the grant of a cable franchise, can require operators provide benefit in the forms of free services to community institutions, to schools, to government buildings, and we can enforce things like requirements for discounts to the elderly or the disabled, and we can in fact ensure that cables provide good customer service. Also, the idea that claims by the operators, by the cable operators, that you cannot require these things can be rejected. It's just not true. That's what the court that's what the commission had said. The court had said no. They were acting arbitrary and capricious because there's no documentation, no basis for this action. And then the third area were institutional networks, and the court found that the FCC had already conceded in their brief that we could require these, since Congress said that we could require them. But what was nice is that the court noted that concession and confirmed it. So that's where we were when we were done with the Sixth Circuit. Now, there was one other issue, and this is vitally important for folks in Texas and California and the other 20 or so states that have state franchises. There was the question as to whether or not the 621 orders applied to states with state franchises, because the only areas that were reviewed were states in which they'd reserve for local governments the right to do franchising. So again, this was important for the folks in Texas to make sure. What the court said was that the FCC has already made clear by expressly stating in the second order that it was intended to apply only to the local franchising process and not to franchising laws or decisions at the state level. Now, that seems like it's sort of, what was even the argument here, Jerry? Well, what the argument was, but they had dropped the footnote saying that while it only applies to local franchising, if any court is asked to interpret these terms, it should refer to us as the expert agency. So they were in fact going to wind up being applying it to state folks by the back door. This pretty much seems to take that out of place. So let me turn it over to Tim, who's going to tell you how all these things are back in play again.
Thank you, Jerry, and thanks everyone for joining us today. First issue is then after the largely a victory by local governments in the Sixth Circuit on the appeal of the second video franchising order, what would happen? Now, as most of you on this call, I suspect, know, at about the same time, 2016, was when the I should say 2017, the following year, is when the new Trump FCC started considering action and issued notice of proposed rulemaking, I guess, in the first quarter of 2017, a wireless infrastructure docket and a wireline infrastructure docket. Among other things in those dockets are the FCC's consideration of industry's proposal to basically place shot clock limits, deemed granted remedies on local government actions in response to wireless applications and in response to right-of-way access, and also to put limits on right-of-way compensation and fees that can be imposed on both wireless and wireline applicants who seek access to local government rights-of-way and possibly other municipal property as well. So that proceeding sprang up after the Sixth Circuit decision in this other docket, in the video franchising docket. So where those matters stood is, what would happen after the remand? Well, sometimes in its history, the FCC just sort of sits on something forever, sort of like they did the reconsideration petition of the second video franchising order here, and they sort of dribble off to nowhere. And sometimes they take very swift action and decisive action, either saying, okay, court, you got me, I agree, or sometimes the agency will say, okay, maybe I didn't provide a good enough explanation the first time. I'm going to provide a better explanation after receiving comment and reach the same result, and that will go up again. Here, as you can see, that basically the options that were before the FCC after the Sixth Circuit, they could sort of restart the video franchising proceedings, basically decide whether they wanted to try to reach the same result with better reasoning or retreat, and then probably issue a further notice of proposed rulemaking on that. Another option, they could decide that there is no need for further action and leave things where they are. And the third option, which you'll see in red, is the cable industry could try to persuade them to take action, but also fold it into not only the video franchising docket, but the pending infrastructure dockets. And that, in fact, beginning with a series of ex partes, which were originally filed only in the video franchising docket last April, and then accelerating in May and June by NCTA and Comcast and Cox and Charter, I believe, decided to take the approach of, yes, bringing up these issues in both the infrastructure proceeding and the video franchise proceeding. Jerry, if you might want to skip 2 slides ahead, and then I'll go back to 9, just to give you an idea. These are the 3 proceedings that the issues are raised in. The first one is the video franchising, and now cable industry has also raised these very same arguments in the 2 pending infrastructure dockets as well. And so what, in fact, are they arguing? Could you go back to slide 9, Jerry, please? And, of course, one of the arguments they make, which is a video franchising argument, is to basically resurrect the mixed use rule, basically arguing that, well, the Sixth Circuit said you didn't adequately explain it the first time, FCC, but we're going to give you an adequate explanation that will be defensible. Their argument, so the argument is, well, in fact, if you read the legislative history as they read it, and the amendments made in '96 to the Cable Act, they argue that, well, basically what the law says is that local governments have authority only over cable franchising, only with respect to cable services, although the cable franchise itself basically gives a cable operator the license to do virtually anything it wants in the rights of way, as long as it's somehow communications service related. Notice I said communications service, not cable service related. And so they argue, the cable industry argues further that based upon their reading of the act, that, as I suggested, the 3 basic points they argue are that their cable franchise gives them a license to use the rights of way to install any kind of communications related facilities and to provide any kind of communication services over their system without any further authority or permitting or anything from the local government at all. They've already got everything they need. And by the way, that brings us to the second issue. They get to do this while still only paying compensation for, based upon their cable service use of the rights of way, not for their non-cable service use of the rights of way. They also go even further and complain, and this is really less of that they're subjected to certain cable franchising requirements that other communications providers are not, or what they're really talking about is the traditional utilities, the local telephone company and so forth. Some of you who have negotiated franchises before know that the typical franchise agreement has provisions about undergrounding facilities. And it's an issue. Usually the general requirement is the cable operator is not required to underground unless the utilities go underground. It varies from place to place. In certain places, utilities are also, when a municipality issues bonding or as a matter of state law, when it does a highway undergrounding project and gets funds or issues bonds to pay for it, that included in the bond proceeds is a fund for utility relocation costs. And so cable operators say they should be entitled to part of that too. Whether they are or can be, again, will vary by state law and locality. In some places they are, some places they aren't. But the cable industry is urging the FCC to declare that in any case where a cable operator is treated less favorably with respect to undergrounding or recovering relocation costs than a utility, that its cost of complying with those undergrounding requirements should be count as a franchise fee and against the 5% franchise fee cap. As any of you who are involved with undergrounding projects generally as municipalities and how much money is involved, obviously, if that ruling were accepted and if there were any differences, query what kind of differences precisely they're talking about and what matter of degree, you could basically eat up your entire franchise fees in no time flat with relocation costs if that were treated as a franchise fee. And now, Jerry, I think we're on to slide 11, which is the local government response. There are responses to these arguments. I'll talk about some of them, and Jerry will talk about some of them as well. And Jerry gets that lead off, and I will follow. So I'll get back to you, Jerry.
Thanks, Tim. So here's the hint. If it sounds like you're hearing the same thing over and over again, you are. Again, what happened is in the early 2000s, the commission puts these things, we think gets them wrong. Sixth Circuit gets them right. And now we're back again and we're having the same battle. So again, the three issues, mixed use. So cable is now back before the commission saying that the commission ought to reinstate the mixed use rule. That is that our local franchising authority's jurisdiction only applies to the provision of cable services over the cable system. Our response is very clearly that the Court of Appeals of the Sixth Circuit last year found that the mixed use rule is arbitrary and capricious and without statutory foundation. We continue to move on. I want to make one practical tip, though. It is vitally important that as we battle this in front of the commission, that you don't give it away at home. A lot of the things that we're arguing about, you could lose very easily with just sloppy franchise drafting. All you need to provide in your cable franchise is the grant of authority to construct, operate, and maintain a cable television system in the public way within the municipal limits of whether it's a city, a county, a village, whatever it happen to be, for the purposes of providing cable service. Some people, instead of saying in the public way, will say in the public rights of way, or they'll spell it out the streets, the alleys, whatever the case may be. But the important thing is that you're only permitting the construction, operation, and maintenance of a cable system for purposes of providing cable service. If the industry, when they come to you with their applications, will be asking for significantly more, please, please, please don't surrender this argument right up front by giving it all away. The other thing is, following on the same theme, the idea that cable franchises do not authorize all uses of the rights of way. A cable franchise is given for the specific purpose of providing cable services over a cable system. If you word it correctly, right? So again, don't give away a win in Washington. Don't give away a win that we might have in Washington or got before the Sixth Circuit with sloppy franchising grants, because that's exactly what the industry is asking for. NCTA has asked the Commission to issue a declaratory ruling that local authorities may not require additional franchises, fees, conditions, or authorizations beyond the Title VI cable franchise, regardless of what the service is. So again, you can give this away in your local franchise if you're not careful. Please be careful. The other thing is that our point is that cable franchises do not authorize all uses of the rights of way. And again, the cable industry is asking for 4 declaratory orders. One, that a local franchising authority cannot refuse to process permits just because the equipment is for non-cable services. And let's bring this to real life. There are local governments out there that are troubled by some of the wireless services that are being deployed by the cable industry without a permit or without even addressing some of the public safety issues. The NCTA wants the Commission to say that there are no additional approvals required for the overlashing of non-cable services and equipment. So the idea here is that if they install it on their wires in between poles, not at the pole, right? Because then they'd have to deal with the pole owner. But if they do it on their own strands in between, they don't have to do anything. Well, in fact, people are stopping traffic to do this. It's a public safety issue. There are rules and regulations that ought to be complied with. The bottom line is that that's not one of the actions that's approved or comes automatically with a cable franchise. So please make sure that you pay attention to that. The industry wants the Commission to find that deployment in the rights of way needs no additional permissions, just compliance with time, place, and manner. So you can tell that they are willing to admit that they can't open up Broad Street during rush hour to do some work, but they do believe that they have the right to open up Broad Street at a time, place, and manner that's consistent with public safety. For any purpose whatsoever, even if it has nothing to do with cable, that their cable franchise gives them the right to do whatever they want in the rights of way. And then finally, as Tim did a really nice job explaining, they want, the NCTA is asking the Commission to issue an order that says the cost of complying with undergrounding requirements that are less favorable than the utilities underground requirements are attributed to franchise fees, or could be credited against the franchise fee and subject to the 5% cap. So that's what they're asking for. Again, please be very, very careful that you don't give some of these things away as you're moving forward. We say that the Commission cannot regulate local government's permitting authority. Section 624 said that we weren't allowed to tell the cable operator what kind of equipment to use for the transmission of the cable. And the industry is trying to now say that means that we can't tell them anything at all about their equipment within the rights of way. Again, we think that that's an awful lot of a stretch. And then finally, Tim, make sure I didn't jump into one of yours here. Actually,
mine.
I am stealing one. Again, Tim, take over.
Okay, no problem. We just have a few minutes left before we hand it over to Garth for his part. So I wanted to make here we're going to talk a little bit about right-of-way compensation and fees, the cable industry's position. And I'm not going to spend a lot of time on the various legal arguments and sources. Their position is that the maximum compensation for use of a right-of-way by a cable system is 5% of the revenues from cable service. And basically any other service they provide over their cable system is immune from any fee, and they get to provide it. They won't use it as a free ride, but that's what I would call it. Their basis for that argument is an amendment to the cable franchise fee provision made in the 1996 Telecom Act. Before 1996, in the original 84 Cable Act, until 96, the franchise fee base was all services, all revenue derived from operation of a cable system, period. So that included any non-cable service. You got 5% of the revenue from that. In 96, the FCC revised that cable franchise fee definition base to include only revenue from the provision of cable services. Cable industry argues, aha, that means that we get to provide broadband, all different kinds of services free of charge over the right-of-way, and we only have to pay 5% of cable service, and if that starts shrinking, well, too bad. They think they're overpaying already. The real answer to that question is no, because they repeatedly ignore the conference report and actually some statements by the FCC as well. The real reason why that change was made in '96 was that absent that, there would be an argument that a local government could require a cable operator to pay, say, 5% as a cable franchise fee on its provision of telecom services, even though as a matter of state law, and the locality could charge no telecom franchise fee at all, so only the cable operator had to pay franchise fees on its telecom services. California would be a good example, a state where the state there are no telecom right-of-way fees for any entity that's certificated by the state PUC. So that's the reason why they did what they did, and they made clear in the conference report that they did not mean to restrict local government's ability to charge telecom fees for a cable operator's provision of telecom service as long as they did it non-discriminatorily. Well, in fact, that's exactly what the city of Eugene did. Next slide, Jerry. In adopting an ordinance that imposed, separate and apart from the 5% cable franchise fee, imposes a separate gross revenue-based fee for use of the rights-of-way to provide telecom service. Telecom service under Eugene's ordinance was defined broadly to include both telecom service and information services or broadband services. And against the very same arguments that the cable industry is now making to the FCC, the Oregon Court of Appeals rejected the industry's argument and upheld the city of Eugene's franchise fee. In other words, it upheld the principle that no, the Cable Act, neither the Cable Act nor the Telecom Act prohibit localities from charging gross revenue-based fees on a cable operator's telecom services or other non-cable services provided over its system, assuming that it is a generally applicable fee that's imposed upon all other non-cable operators who provide telecom and broadband service and use the right-of-way. And basically, in the proceeding before the FCC now, the cable industry is asking the FCC, in essence, to overrule the City of Eugene court decision. And it's also basically arguing, the essence of its argument is that basically, yes, we get to provide telecom services and any other service over our system without paying any additional fee for it beyond the 5% we pay on the cable service revenues. Next slide. And finally, because our time is about up, and we can always be hopeful, and I'm not going to say for sure what the FCC is going to do, but I think the odds, if you believe what the commissioners and the chairman say, at least the GOP commissioners and the chairman have said in their public statements, it seems highly likely that the FCC will rule as early as September, maybe October. It will more likely than not accept the cable industry's arguments, in which case, to defend their rights, local governments are going to have to appeal, and that's probably something they need to think about preparing for now. And with that, I will hand it back, and thank you very much for your time.
And we'll note the fact that we did finish in time. Garth?
Yeah, great job, guys. You covered a lot of territory there. So I guess burden's on me now, huh? Okay. Welcome, folks. I want to remind you that we would appreciate you posting your questions out there so that we can have those available to address at the end here. What I've got up here is just, I'm going to try to run through this quickly. Some of this you've seen posted on the listserv, but what we're going to talk about here is just fees and rents and, where things stand today. Obviously, the current methods for charging rent, on video is a percentage of video revenue. And that's defined by your franchise agreement. You also have folks in your rights-of-way, though, that are utility users, and it can vary by state law. Sometimes the electric company pays a fee. Sometimes the telephone company doesn't pay anything. But those methodologies vary. Folks lose sight of all the other folks that you have in your rights of way. be it data companies, wireless providers, even your local government and vehicles and people. You have to think about the entire gamut of folks who are using your rights of way when we get into what I'm going to talk about here. And some of those other users, be it a restaurant who's using a sidewalk, or a data company that's using, putting data in your rights of way for a few blocks. A lot of times those are covered by encroachment agreements, and it's negotiated. The other thing that I want to point out here is that folks always seem to lose sight of the fact that usage can be above and below ground. Okay, you'd be amazed at how crowded the underground is getting these days. And when I talk to folks about it, there are certain parts of your cities that are specifically difficult to get into underground. What's a risk? Well, the obvious thing is that your loss of revenue. You've got a responsibility to manage your rights away and not give it away. But with the way that things have been going recently, these rents that are being charged, especially for video, they're declining, or they're starting to decline. It's been disguised because you have increases in revenue per subscriber, but you have declining subscribers. So when it reaches that tipping point and starts going down, you're going to have a noticeable decrease in those franchise fees. And for those of you who use gross revenues for your PEG fees, you will notice that PEG fee is going down also. Now, our guys here, Tim and Jerry, have done a great job giving you a background today, okay? That, there's been I don't want to say an attack, but what they're trying to do is, like I said, erode your ability to manage your rights away. Now, what I'm going to talk about here, it varies by state, and there are different pieces of this that can be done differently in states. But the easy approach. Well, the easy approach is just continuing what you're doing and know that you have a risk that you're going to have diminishing revenues over the coming years. And what I should point out here that what I'm talking about is the movement of video from your traditional cable service to an over-the-top, an internet protocol service. And as those things occur, your franchise fees will go down. Okay. The other thing that I'm doing and working with people on, though, is doing a charge based on occupancy, the cost approach. But obviously, you can do a market value, a revenue-based market value, a storefront rate, an incremental approach like a what-if rate. But one of the ways that I want to talk about today. I'm sorry,
Garth, but you're making very clear that this is for use of the rights of way, and if you're doing it for a cable franchise, you'd have to be able to document that it's not exceeding 5% of gross revenues, right? I mean,
and then
okay. I know that you know that, but I just wanted to make sure that folks aren't sitting there going, "Ooh, well, let's get out of the 5% world and we'll go into one of these new worlds," and we really can't. So, okay, again, I'm sorry.
And no, you're right, Jerry. And some of the work I'm doing right now is in New Mexico, for example, and they can't even charge the 5% unless they can have a cost study that shows that they can do that. Okay. But like I said, all those things vary by state law. Now, the one thing I want to get into here is the differences of the cost structures between a fully allocated cost, which is the way that I do it, and some other people do it, which is based upon the way utility rates are set by your public service commissions, your public utility commissions, as opposed to what the FCC and some of the legislation is out there today. Okay, it's a fully allocated approach. The first thing you have to understand is that your government does not maintain this data. Okay. You have to develop it. I haven't been with anybody yet that that has this data and in a usable format. Okay. Do you know who's in your rights of way? Most folks don't. You that's I know that sounds difficult to you, but you know, you may know that the cellular companies are there, but you don't know to what extent. You don't know their exact locations. They tell you that information's confidential because it's competitive, but you can't charge for it if you don't know it's there. Okay. And then when you're talking about trying to develop a cost structure, what costs within your city are related to your public rights of way? And the obvious thing that comes to everybody's mind is public works, streets. Well, there's a lot of planning that goes into those streets. There's land that those streets are on. There's maintenance costs that are associated with those streets. You have stormwater on the sides of the streets. And police and fire are the biggest cost centers in any local government. And they spend a lot of time in your rights of way, and a lot of what they do is related to activity in the rights of way. Just as an example, if you have a chemical spill in a right of way and it impacts a utility provider, then those things have to be considered. I've been involved in a case where we had a high pressure gas line in the rights of way, and the fire department had to be trained to handle that high pressure gas line in case there was an accident. Recently, I was asked about a gas line of jet fuel going to an airport in the public rights of way. So those are things you have to think about. Now, the other side of it is, what kind of cost do you have to support those people? Obviously, finance and budgeting, human resources. I've given you a list here, but it varies by city and by community. All of these departments vary by city and by community. You can't look at this list and say, well, that's how it works in my community, because you don't know until you actually get a chance to dig into what these people are doing. Now, when you're dealing with this in the long term, the one thing that we try to recommend to folks is that they develop a procedure. You got folks that come in and want to have access to your rights of way, then you have to know if they have a right to be there. If they don't have a right to be there, then how do I initiate a process to start that? If they're going to attach to another person, another user of the rights of way, do they have the rights to do that? When you look at the location, the size, I mean, folks never think about clearance that's required when you put a wire in the ground. Most of your cellular companies, your data companies, your telephone companies, they require a 2 or 3 foot clearance when that wire is put in the ground, so that it's not only the occupancy of the size of the wire, it's all the other space that they're taking up also. And now, this is stuff that I put out there in response to some questions on the listserv. I'm not going to spend a lot of time on it here. I'd like to spend more time on your questions. But just note that in the current draft that we have from the BDAC is that a lot of the stuff that they're looking at is incremental cost. And when I say incremental, they use terms that are, they use the terms actual and then infer the incremental. The problem with that is that there's a lot of things that can go on within a community that where you're trying to prepare for folks to use your rights of way, that then you're going to get arguments that come back to, is this an incremental cost associated with me being in the rights of way as opposed to the guy who came before me? Just as a ridiculous an example, you can think about an airport that's built and all the costs in the airport go on the first guy who lands the plane. Everybody else only has to pay the little charge that they have associated with landing. Again, the same thing I've got here in costs that you've seen out there before, the make-ready costs. These are incremental. You'll note here that if you had to use a consultant or incur consulting expenses, those would not be incremental that you could recover. And they did note, BDAC did note that if you wanted to give it away, that was permissible. Okay. It's nice that they're allowing you to give it for free.
It may be permissible under the BDAC, but make sure that you don't have an anti-gifting rule in your constitution or in your local code, because that doesn't let you do that.
That's right, Jerry. That's what I was trying to say earlier, is that, you have a responsibility to recover the costs. And then on the municipal side, VDAC didn't go into a lot of detail about this, but it made it sound like that all the things they were talking about on a state basis were going to apply to municipal governments. And they made a big deal about confidentiality. I don't know about your part of the world, but the part of the world that I deal with my clients, just about everything that local government does is in the sunshine, so that there isn't any confidentiality when somebody has a contract with a city, unless it's specifically laid out that way. And usually those are difficult to have. So that anything regarding those contracts with the use of your rights of way should be something you could get access to and use in making your decisions. Finally, here I just wanted to point out that under the Thune-Schatz bill, that they're also talking about incremental. I'll leave it to the lawyers to tell you how all that falls out. But don't think that that Thune-Schatz bill is going to save you in any of this. Okay. And with that, we're open for questions.
Thanks, Garth and Tim and Jerry. This is Nancy again. I really appreciate everything you guys had to say, and I appreciate that there's time left for questions, and we do have some questions. And before we get into those, I do want to just quickly mention that the eNATOA annual conference is coming up in August. It's the last week of August in Philadelphia, and we have multiple panels that are going to be addressing these types of issues, the cable industry issues, as well as the 5G wireless deployment issues. And we actually have a pre-conference day on August 27th, dealing directly and only with rights-of-way related issues, including fees. So there's a lot coming up at the annual conference to dive further into these issues. So with that, keep your questions coming.
Sorry, Nancy, where is that conference going to be held? What city?
It's going to be in Philadelphia, Jerry. Do you want to comment on that?
The home of the Super Bowl winning Eagles? Okay, I'm just...
Don't make me mute you, Jerry. Don't make me mute you. Okay.
All in all, I'd rather here than in Philadelphia.
Okay, so, W.C. Lay.
So, Tim, the first question that I have a couple of questions. One question was asking you to clarify the changes in the 1996 Act that changed the language about the 5% fee on cable for cable franchises and why that change was made. And there was a second question asking if the 5% cap only applies to cable service. So I think if you could probably discuss those together, that'd be great.
Yes. I mean, the answer to the second question is yes, it only applies to cable. But what happened, and it's very complicated, is between 84 and 96, the original Cable Act said the franchise fee could be no more than 5% of revenue derived from operation of a cable system. So that included cable and non-cable services. That's one reason why franchises back then were basically broad grants to provide not just cable service, but non-cable service. In 96, you'll have to remember, one of the things Congress was trying to promote was competitive entry to traditional telephone carriers. Cable operators were, of course, viewed as a potential provider, potential competitor to local telephone companies. The the cable industry was concerned that, wait a minute, if we have to pay 5% on everything, including our telecom services, what if the incumbent telephone company doesn't have to pay anything on its telephone services, but we, because we're under the Cable Act, would have to pay 5% on that? Well, Congress, rightly or wrongly, decided, okay, we hear you, so we're going to shrink the cable franchise fee base to be just operation of a cable system to provide cable service related revenues, no longer telecom service. But when it did that, Congress made clear in the conference that we do not intend what the cable industry says they now intend, and that is Congress made clear in the conference report that this is not meant to suggest that localities cannot impose reasonable fees on cable operators' provision of telecom services. They said that there. Also, the FCC, curiously, said that also, and said it was so obvious that it used the term "of course" in a footnote in its second video franchising order, the order we talked about earlier. But nonetheless, if you look at what the cable industry's argument is, look, cable franchise fee based limited cable service. Cable system under the Act can provide non-cable services. Ergo, we get to pay only on cable service and can use it, nevertheless use our system in the right of way to provide all these other kinds of services. That's what their argument is. We disagree with it.
All right, thank you, Tim. And then Garth, I had a question for you. And you mentioned that you worked on some cost studies, right-of-way cost studies. Have those been litigated? And if so, what happened?
Well, I have to be careful here because one of them's in litigation right now. In Metro Nashville, we had that was litigated. It was litigated in state court, and the city prevailed. Our cost study held up, and the city is able to charge for usage of rights of way. The big player in there that was litigating it was AT&T for their wireless use. For their wires that were located in the rights of way for their competitive service provider.
And just to be clear, your cost study goes beyond incremental costs. You were talking about incremental costs being included in some of the BDAC recommendation and some federal legislation that's pending. You're talking about a cost study that goes beyond incremental costs, right?
Well, we're talking about a fully allocated cost study, yeah. And that includes all of the city, local government's costs to own, manage, and maintain its rights of way. So yeah, it's not an incremental. It's fully allocated. It's actually based on the same way that the phone company charges you for use of their system.
And again, Garth, I really loved your example that incremental cost means that you're the second plane landing, and you're only paying for what you use, as opposed to fully, capturing all costs is what the cost of the airport was, and it needs to be divided equally or fairly, not necessarily equally, but fairly among all providers, and that's really the difference between what the industry wants and what local government's talking about. Nance, can I just make one point, though, on cost and rate of recovery and rights of way? Please, folks, always make sure that you check with your state law, because while federal law, it talked about the 5% cap on cable, what you can charge for use of your rights of way many, many times is set at the state level, and you don't want to run afoul of that.
Yeah, thanks, Jerry.
Jerry, let me supplement that by saying the additional problem you have in state law is that state law allows you to charge, for example, the electric company, but not charge the telephone company. So those are things that you have to watch out for.
Right.
All right, thanks. We had another question about litigation. There was a question of whether or not wireless right-of-way usage fees have been litigated. Anybody want to take that one?
Well, the occupancy that I was talking about in Nashville doesn't specifically address wireless, but it would allow for wireless to be charged for. So I don't know, Jerry, Tim?
If I could, just for a half second, the biggest misnomer of all is the idea of wireless services. It's only wireless to the end user. The network itself is composed of two wires. So every time you've got a wireless device for sending or receiving or both, it's always going to be connected to two wires, a power wire and a communications wire. And there's an awful lot of issues right now on, who's got the right to deploy the wires, and that's sort of being resolved either through state legislation or in some cases litigation, and whether or not an entity that's got the right to be in the rights of way to be a wireline provider also then has the right to use those same wires for wireless services. And so it comes down to whether or not that person is a protected entity under Section 253 or under 332. And that's what we're working through right now. I can't point you to any specific litigation that has moved forward on that issue. If there's something I'm missing, we'll make sure that we put it in the packet when this comes out from eNATOA.
There are a couple of cases I'm aware of, but they're not really addressing, for the most part, the federal law issues. If the question is dealing with permitting, litigation over the level of fees that 332 or 253 would allow for wireless facilities, no. But there is pending litigation in Texas, but it's really local governments challenging a state wireless siting law and challenging the constitutionality under state law of the rate set by the state legislature per wireless attachment, arguing that is a gift of sorts. So and there's one in Austin and one in
McAllen.
Yeah, McAllen. Yeah, Rio Grande Valley. There also was, I don't know where it is now, a challenge to Ohio's small cell legislation, but again, that was based upon the challenge was based upon state law.
Well, what happened in Ohio, Tim, was that it was mooted because they went and repassed the second law. In Ohio, it was based upon the fact that they had violated their own state constitution of one issue per bill. And there it was found that they had actually combined an SPCA, a pet care bill with small cells.
Yeah, so
but that's been mooted, right?
The issue has not been resolved as far as a matter of federal law. I mean, what's happened in most cases is about 20 states have passed small cell legislation, which basically sets ceilings on rates in those states. Elsewhere, the industry has come to agreement, and there's a wide range of fees. I'm not aware of there's actual pending litigation about it. That doesn't mean there isn't, but beyond the ones I discussed, I'm not aware of any.
All right, thanks. We also have a couple of questions on, what can local government do? It's specifically, you said in your presentation, Tim and Jerry, they need to be taking some action and making their voices heard at the FCC. So a couple of questions related to that. One is a question about the ex parte rules and the sunshine period. So if we can give listeners an overview of when they can file or when they must stop filing comments in response to the NCTA filings, and then just general comments on, how best to allocate one's resources in terms of responding to the FCC issues that are going on.
Well, I'll speak to the our ex parte rules. As many of you on the phone know, I mean, the FCC ex parte rules provide that if a matter is on the FCC open meeting agenda, all ex partes must cease at the time of the sunshine notice, which is 7 days before the open meeting. And further ex parte filings on that matter are prohibited until the text of the FCC's action is released. Now, as an esoteric question, there is a matter in this docket, in the relevant infrastructure docket on the FCC's open meeting agenda for August 2nd. So that would mean that ex partes on that topic would be barred after, basically after this coming Thursday, July 26th, and they couldn't resume until the full text of the declaratory ruling and one-touch make-ready action the FCC has on its August 2nd agenda is released. So the safe thing to do if you're planning on filing an ex parte is either file it by this Thursday or file it. I suspect the full text of that FCC decision will come out pretty soon after August 2nd. My guess is if it doesn't come out Friday the 3rd, it will be out by Monday the 6th or 7th. So that would basically be the safe blackout period. Now, an argument can be made that you don't have that it doesn't apply to the cable industry ex partes because that issue is not in the draft order. There's not clear FCC precedent one way or another. It just depends on how aggressive or conservative you want to be. But either way, I think the window will open back up by August 6th or 7th, which will leave a significant time between then and the FCC's late September open meeting, which is their next open meeting.
I guess maybe I read things more aggressively. I didn't hear us talk about one touch make ready or moratorium on for deployments in the rights of way once in our presentation today on the three issues that are being addressed. So as far as I'm concerned, make the filing now, make it next week, make it whenever you need to make it. If you're addressing mixed use in kind or the benefit or the limitation of a franchise to provide simply cable services. I think it's crystal clear, and I promise you that Tim and I and Nancy will put something out on the policy listserv and the member listserv telling you when sunshine comes due on any of these matters. But please just file. I don't see any limitation here at all.
Yeah, and Jerry, thanks for mentioning Nancy there. I think folks, you need to continue to work with eNATOA as well as your outside counsels on all these issues.
Yeah, thanks, Garth. We do, at eNATOA, we really do appreciate, we want to work with you, and we also, if you filed something with Jerry, with Tim, if you copy me on it if you don't mind, because I like knowing what's out there. It helps because we can cite each other and things like that. We have a few more minutes. I wanted to jump back to a quick question for Garth, and then if we have time, maybe we can get on to the Soon Shots bill as well, just briefly. But Garth, you talked about, there's obviously the 5% limitation in the Cable Act, and then there's various state law limitations people have to be aware of. But, putting that aside, you talked about, different ways of charging users of the rights of way. Were you talking about, I assume you're talking about more than cable, you're talking about other users of the rights of way? What have you been working on and recommending to your clients?
Well, anybody that occupies the rights of way, you have to determine the costs associated with them, and be it the water line, the gas line, the electric company, data company, whoever. And you can establish what those costs are that need to be recovered there, and then the local government has to make a decision about how they want to handle it. For example, some of those costs are going to be associated with pedestrians and bicycles. Are we going to put on a pedestrian tax and a bicycle tax, or are we going to say that that's recovered in our general revenue? So those types of things. But no, we're talking about charges for everybody who uses the rights of way. That goes into the equation. And yes, this is being implemented to charge folks, as Jerry said, when they drop those wires into the rights of way, for anything where they're there. So yeah, and I should also mention, we kind of recommend you do it on a cubic foot basis. Linear feet can give you some really weird answers. When you're looking at a coaxial line as opposed to a sewer line, they can have the same linear feet, but they can occupy a lot of different space. So.
Thanks, Garth. We did have a quick follow-up question on the sunshine period, asking if Chairman Pai's practice of releasing advanced copies affects the sunshine period. And you guys can jump in and correct me, but it doesn't. The drafts are released a few weeks ahead of the meeting, but then there will be a final, they call it a sunshine agenda that comes out a week before, and that's when the period actually starts.
You're correct. In fact, I'm not sure I fully agree with what Jerry said about the ex parte, but it does improve the argument because now, since there's a draft of the order out and you see what's in the order, you have a stronger argument saying this ex parte doesn't have to deal with what's on the agenda. which when you didn't used to have them. But yes, the short answer is the sunshine period. In fact, the reason the FCC releases the draft order, it shoots for 3 weeks before the meeting, is to give people 2 weeks to ex parte on the draft order. Now, the only other thing, you won't go to jail if you violate the ex parte rule. But the FCC might issue a public notice saying notice of prohibited sunshine ex parte and have your name on it and knock that out of the record, which means you'd have to refile. That's what the sanction would be.
So make sure you file it in more than one proceeding.
And so there was one more process type question. Someone asked if one takeaway from the long time it took for the 621 reconsideration petition to be ruled upon, if you recommend against filing reconsideration petitions as a rule because of the delay in getting a response.
I'll jump first. I said no, because it depends on. First of all, there are several different reasons why someone might file a recon petition. You might file one to get in parties who weren't in the proceeding before. You might file a recon petition to get in an argument that's not in the record yet on your side, so it's there when you take up for appeal. So there are lots of different reasons. You also might file a recon petition for delay. It varies. Now, there are reasons not to file a recon petition. That is true. If you don't want to give the FCC a second bite at the apple, don't file a recon petition. But it depends on the specific issue, the specific order, and also who the parties are. So I don't think you can have a general rule like that.
And in this case, if we hadn't filed a reconsideration petition, then we wouldn't have been able to appeal the order on recon, and we might be in a position where in-kind contributions are being counted against franchise fees. The mixed-use rule would still be in place. And there would be stronger arguments in favor of cable being able to do whatever they wanted in terms of the rights of way because they have a cable franchise. So, in fact, I think in this case, the recon gave us a second bite at the apple, and luckily for us, the Sixth Circuit was amenable to our arguments.
All right, we are technically out of time, but I'm going to use my prerogative as the moderator to ask one more question, and hopefully this won't take too long. But Garth had mentioned the Thune-Schatz bill. He mentioned specifically the fact that it includes a limitation on recovery of right-of-way use fees that would be incremental costs only. But I was wondering if anyone would just give a very brief overview of what else is in that bill, and again, any sort of encouragement for folks to take action in opposition to that bill.
Yeah, Tim.
You were going to jump, Jerry? I was going to let you jump.
No, I said go ahead if you want to go. I mean, my problem is I'm not sure that I can give a quick answer.
I'll give a quick answer. That one of the most troubling things is limits right-of-way compensation to direct costs. That is true. That is very troubling. It also codifies, in other words, puts in the statute, not FCC rule, shot clocks, and so it also places complicated new hurdles that local governments have to clear in order to justify any decision denying or conditioning. In other words, when it talks about matters such as appearance or safety or other things like that, you have to have clearly articulated and objective. What is an objective appearance standard? I don't know. But basically, these are just hoops and hurdles that a local government, that are basically every single one of those hoops and hurdles is another hook a provider can use to challenge a local government's action as contrary to the new provisions of the act that the bill would add. Beyond that, Jerry's right. It's kind of complicated to walk all the way through it. But yeah, that's the problem, is it basically gives access to state and local property at cost, which is sort of strange. And I'll let Jerry jump in here how sort of hypocritical it is. The act that they passed earlier, the federal government, however, allows its property to be charged out at market rates, but apparently state and local governments are to be stuck with direct costs.
Yeah, Tim has it exactly correct. There's a position paper on the bill that Tim and I worked on together with Nancy, and if you don't have it, just send us a note. We'll send it to you. I mean, the bottom line is that we believe that the Thune-Schatz bill imposes unrealistic timeframes. It converts public property into corporate assets while imposing no public obligations in exchange for those benefits. And that's really the heart and soul of what's troublesome. Tim walked you through all the other things about, the transfer of the property, the shortening of the shot clocks, the creating of deemed granted relief where today you have to go to a court, shifting, going to the local federal court is a protection that's in place today. They would get rid of that and make everybody come to the FCC and be held hostage. So yeah, it's a real problem. And it also, the bottom line is that today there are existing safe harbors with respect to fair and reasonable compensation, and they're going to get rid of that to actual and direct costs. So yeah, it's a very troublesome bill that gives everything it can to the industry and requires nothing from the industry in exchange for those benefits. And that's real troublesome.
Yeah. And I'll just add that the Senate Commerce Committee is having a hearing on July 25th that is titled something like the race to 5G spectrum needs or something like that. But Senator Thune has indicated that they intend to talk about this bill at that hearing, and the I think 4 witnesses at this point are all industry representatives. So as far as I know, there's no vote scheduled on the bill. Again, jump in if I'm incorrect here, but I just want to note that there is going to be a hearing that, if you just looked at it on the surface, would not indicate that this bill is going to be discussed, but apparently Senator Thune has stated that it will be.
He'll probably bring it up. There will be a separate hearing on the bill itself, or a markup, I think, or whatever. That won't occur this Thursday. But I mean, I'd be sort of surprised if, I should say Thursday, it's Wednesday. But all Thune said is that he might bring it up, and then questions to the witnesses I could see coming up. And of course, I have a pretty good idea what the at least the 2 non-Qualcomm witnesses would say, because.
Yeah. Okay, well, we have gone over time, so I want to thank, again, our panelists very much for your time and your expertise and for sharing all of that with us. Thank you, everyone, for attending. And again, our annual conference is the last week of August in Philadelphia. Jerry, there was a request for you to give people some ideas on where to go, so you can stay on the line a couple extra minutes if you want, but hopefully we will see all of you there. And we do have another eNATOA coming up in early August, I believe, as well. So thank you, everybody. And Jerry, if you want to stay on and chat about Philly, go ahead.
So here's the secret. Don't just run up the art museum steps and play Rocky. Go in. It's worth going into. Bye, everybody.
Thanks, everybody.
Bye-bye.